My name is Diletta Marchesi, and today I'm going to report the findings of the comparative research we've done within the Emprise project on the drawing of adverse inferences from criminal suspect silence and human rights protection. Our research sheds light on what is a prominent point of controversy around the right to remain silent in European human rights law, whether and under which conditions it's possible to draw from the suspect's silence adverse inferences, namely conclusions drawn from the suspect's silence or failure to provide certain information during the criminal proceedings that can have a negative impact upon determination of criminal responsibility or the assessment of evidence. Adverse inferences are somewhat in tension with human rights protection, as they are often considered to be as a subtle compulsion to speak that deprive the right to silence of any meaning. Adverse inference provisions have been introduced in the criminal procedural laws of many common law countries. As a consequence, it may well be thought that the right to silence is better protected in civil law jurisdiction. However, as demonstrated in this research, adverse consequences can flow from silence in both types of systems. Our research is based on the comparison of 3 European Union jurisdictions with differing procedural traditions. Ireland, a common law jurisdiction with an accusatorial criminal process. The Netherlands, a civil law system with an inquisitorial criminal process. And Italy, a civil law system with a hybrid, mainly accusatorial criminal process. The research highlights that, despite the existence of both European and domestic legal protection for the right to silence within foundational sources of law, each has introduced, in one manner or another, procedural and evidential consequences for suspects who do rely upon the latter right. And in fact, the 3 jurisdictions reveal the different ways in which adverse inferences from silence can become a feature of criminal procedure. Considering the sources, by statutory development, like in Ireland, which has created a slew of statutory inference drawing provisions, or through case law, like in Italy and the Netherlands, following a more bottom-up approach. Considering how, framed as permission to draw inferences with safeguards and limitations, like in Ireland, or framed as exceptions to a general prohibition, like in Italy and in the Netherlands. This has been also facilitated by the adhesion to the principle of intime conviction of judges, the principle of free interpretation of evidence, which allows the judge to assess the behavior of suspects throughout the proceedings, including silence. The research explores differing approaches to the practical operation of inference drawing procedures, including threshold requirements, varying evidential use of silence, and procedural safeguards. On the first one, varying threshold requirements for the drawing of inferences seem to have been established across the 3 jurisdictions. The Irish legislative inference provisions have differing inbuilt threshold requirements, but each of them insists that a suspect should not be solely or mainly convicted on the basis of an inference from silence. The Dutch courts have followed the European Court of Human Rights' insistence that a prima facie case should exist against the suspect before an inference from their exercise of the right to silence can be drawn. In Italy, the Court of Cassation argued that silence can be taken into account only together with probative accusatory elements with an unequivocal meaning that admit a single explanation. The threshold seems to be higher than the one required by the European Court of Human Rights. Moving to the evidential uses of silence, our comparative analysis shows that inferences from silence, as they operate in practice, have differing evidential purposes, which are particularly difficult to discern. A first use that has been observed is the one aimed to undermine the credibility of a defense or an exculpatory information raised at trial. A court may infer from the suspect's pretrial failure to mention a fact which is relevant to their defense at trial, either that such defense is a recent construction to suit the prosecution case, or that the defense is simply untrue, and or that the suspect is guilty. Under Irish law, the defense must provide the prosecution with advance notice of any alibi on which they will seek to rely at trial. Failure to do so will preclude the defense from introducing such evidence at trial unless the trial gives leave. In the Netherlands, there is no statutory rule obligating suspect to give notice or alibi or other defenses. However, if a suspect invokes a defense ground such as justification or excuse and invokes the right to silence, this is likely to make their defense in court unsuccessful. When the suspect invokes the right to silence, the court will also be more reluctant to accept a mere and varts defense, a defense that argues that the facts and circumstances used for a conviction also fit with an alternative, not highly improbable scenario in which the suspect cannot be blamed from the offense. In Italy, the adversarial principle and the presumption of innocence allow that where the defense wishes to provide exculpatory evidence, it may do so after the prosecution case has been presented. However, it's not altogether clear, at least considering the case law of the Court of Cassation, if a suspect's initial silence can be relied upon to undermine the later revelation of a defense. Moving to other purposes, at times courts seem to use inference as corroborating or supporting evidence, sometimes to assist in interpretation of other evidence, and on other occasions as validation of the prosecution case in the absence of a counter-narrative from the defense. Our comparative analysis demonstrates differences in how the examined jurisdictions approach the evidential value of adverse inferences from silence. Often, these purposes are not expressly stated in the law or case law, but they must be inferred from the court's reasoning. Irish legislation does not clarify the exact nature of the inferences which can be drawn. It's impossible to tell what weight juries give to inferences, but it's quite possible that an inference could play a significant role in the totality of the evidence in a given case, as the applicable standard is simply that an inference should not be the sole or main grounds for a conviction. However, it would appear that the actual value of inferences as an item of proof is low as compared with items of real evidence. Dutch courts stress that silence cannot be used to fill in gaps in a weak prosecution case. However, they appear to attach relatively significant value to inferences, expressly stating that an inference may tip the scales in favor of a conviction, where the available evidence is insufficient to meet the evidentiary burden for a conviction. They also allow other, more indirect uses of inferences from silence, especially in cases of corporate perpetration, money laundering, and aggravating trading of stolen goods. Italian courts argue they use the silence of the suspect during pretrial questioning as an element of guilt against the suspect is impermissible. However, it can be used as a residual and complementary sort of tool to interpret other, rather strong, incriminating evidence. The weight of inferences seems to be more substantial where the evidence points to the responsibility of the suspect, and the suspect fails throughout the proceedings to offer an explanation of the event. This will represent an implicit validation of the existing evidence. Moving to the issue of procedural safeguards, the Irish statutory inference drawing provisions come with a list of safeguards. For example, the suspect must be afforded a reasonable opportunity to consult a solicitor prior to the relevant silence and must be told that a failure to provide certain information in the police station can be later drawn to the attention of the jury. The express provision of specific safeguards is definitely one of the benefits of an overt system or an overt legislative approach to the drawing of inferences from silence. But for example, it's not clear the threshold requirement for a suspect response during police interrogation. If a suspect has not been confronted with all of the evidence in existence against them, are they to be expected to provide all sorts of facts to the police so as to avoid a potential future inference being drawn? Contrarily, in Italy and the Netherlands, where the emergence of inferences from silence has occurred through the judgments of the courts, the limitation and safeguards concerning inferences specifically are less clearly spelled out. But this, of course, does not mean that there are no forms of safeguards at all. In particular, in Italy, the system provides relatively strong protections for the questioning in general, for example, concerning the right of access to a lawyer, documentation, recording of the questioning, the informational rights. However, the Code of Criminal Procedure does not request authorities to detail the consequences of exercising the right to silence. The issue is common also in the Netherlands, where courts consider that the suspect should know as a matter of common sense that a failure to provide exculpatory evidence might have negative consequences at trial. Moreover, failure to provide sufficient details to police or changing these details at the later stage after suspect obtained access to the case file may contribute to the finding that the suspect's exculpatory account is not credible. This research shows the value of cross-jurisdictional contextual study, especially in a European context. Notwithstanding the fact that all three systems have subscribed to the right to silence, none of the three systems de facto consider it as absolute. But there are important differences in their inferences drawing regimes, some of which may be attributed to the nature of their legal procedural system. The study made clear that, even in jurisdictions which appear not to have inference drawing provisions, inferences from silence might yet be a matter of practice. We argue that the question to be posed by European human rights standard setting institution is not whether adverse inferences from the suspect's silence in criminal proceedings should or should not be authorized. Rather, instead of trying to achieve stronger formulation of the scope of the right to silence in the national laws of member states, further harmonization could be achieved through encouraging member states to provide greater transparency and foreseeability of the provision on adverse inferences from silence, as well as to introduce appropriate safeguards for their use. Although the case law of the European Court of Human Rights or the Court of Justice of the European Union could help to this purpose, an alternative, more assertive approach would be for the European Commission to issue non-binding recommendations or guidelines to member states pursuant to the Directive on the Presumption of Innocence, to clearly establish European-wide minimum standards on the actual operation and use of inferences drawn from silence, and to require the clear implementation of procedural protections, such as those outlined herein across member states. This ought not to be seen as an encouragement to introduce inferences where none currently exist, but to clarify their operation and related procedural protection where they do. The following are where attention should be focused. First, a central safeguard is the evidentiary threshold. To define the tipping point, courts use different and vague formulation. Although it might be challenging to identify one single definition of this threshold, it might be suitable to provide general guidelines to this effect, along with procedural requirements of how the evidentiary threshold should be assessed. Another safeguard would be defining the purposes for which inferences from silence can be used, which is not discussed in any detail in the respective European Court of Human Rights case law or the EU Directive on the Presumption of Innocence. For which purposes silence is used in the different jurisdictions is difficult to assess, and sometimes it reaches contradictory stances. It's prohibited, but let's use it anyway in certain cases. We therefore call for more reflection with regard to the legitimate purposes of inferences from silence, along with the requirement of transparency in respect of these purposes. Thirdly, particular attention should be paid to procedural safeguards, including informing suspects about the possible downstream consequences of silence, sufficient disclosure of evidence before calling the suspect to account, and ensuring access to effective legal assistance so that they can make fully informed decisions on their approach to questioning. Procedural safeguards against inappropriate use of adverse inferences from suspect silence are not merely formal requirements which distract fact finders from establishing the truth. They are meant to ensure that persons in contact with the justice system and the public in general have confidence that exercising the right to silence will not be unduly penalized or lead to unfair treatment. Thank you very much for your attention.